Hello friends, very warm welcome to my business laws channel. In my last two videos friends, I have covered frequently asked questions in DU and other examinations. And those acts were the Indian Contract Act 1872 and the Sale of Goods Act 1930. So friends, today in this video lecture class, I am going to cover frequently asked questions in the U and other examinations pertaining to special contracts. You know friends, there are three special contracts. First one is contract of indemnity and guarantee. Second is contract of bailment and pledge. And the last one is contract of agency. And these questions and how to answer these questions, all I will cover in my today's video lecture class. First one is friends, contract of indemnity and guarantee. Very often question is asked on this. Define the term contract of indemnity and discuss its essentials. Now you all know friends, contract of indemnity has been defined under section 124 of the ICA 1872. There are 7 features, 7 essentials we can call characteristics, features or essentials. So 7 points you will have to write with examples and content theory. Okay, so that completes the answer for this. Second question is difference between contract of indemnity and guarantee. Indemnity has been defined under section 124 and contract of guarantee has been defined under section 126. You all know friends, in contract of indemnity, one person indemnifies another to make good the loss. We have two parties, indemnifier, the person who makes good the loss, and indemnified or indemnity holder whose loss is made good. And in case of guarantee, guarantee is a contract where one person promises to discharge the liability of another person in case of his default. The 3 parties involved. The person who guarantees or discharge the liability of other person is known as surety, and the person who lends the money is known as creditor, and the person who borrows the money is known as debtor. So surety gives the guarantee to the creditor. You lend money to the debtor or you sell the goods on credit basis to the buyer, and I will see to it that you are paid. So friends, number of distinctions are there. First is always the meaning. So I've told you in my previous videos also that distinction you should always write in the tabular form. There are 8 to 9 points of distinction between contract of indemnity and contract of guarantee. So all 9 points must be written in the tabular form. Okay, and now coming to the next question, which is extent or nature of surety's liability. Explain the extent and nature of surety's liability under the Indian Contract Act 1872. So under this question, friends, you will have to write the points pertaining to extent and nature of surety's liability. To what extent surety has to discharge his liability? Surety's liability is always secondary. Primary liability is that of debtor. It will arise immediately on the default committed by the debtor. His liability is dependent. It is dependent whether default is committed by the debtor or not. And it is coextensive with that of principal debtor. If there is no contract to the contrary, then as per section 128, whatever amount debtor is liable to pay for, the similar liability has to be discharged by the surety. Surety can always limit his liability. It is not necessary, friends, that surety should give the guarantee for 100% debt. He can always give the guarantee for 100% if he wants, or he can reduce his liability. He says, I will give the guarantee for 50%, 60% or 80%. So that is why we say he may always limit his liability. And then it is not there that sometimes we find the surety is discharged, but principal debtor is not. And sometimes we find the debtor is discharged, but surety is not. So discharge of principal debtor would not always mean the discharge of surety. So friends, so these 6 to 7 points you will have to write in the answer for this question. Next question is rights of surety against different parties. Question may be asked, friends, explain the rights of surety against different parties. Then you should know which are the different parties. Different parties are creditor, debtor and co-sureties. Rights of surety, or question will be asked that explain the rights of surety against creditor, debtor and co-sureties. 4 to 5 points are there under each heading. Who is the surety? Define first of all, then write the make the three-way classification, and then under each you have to write the sub-points. Rights of surety against the creditor, rights of surety against the debtor, and rights of surety against co-sureties. When guarantee is given by more than one person, then each one of that person is known as co-surety. Surety has some rights against the co-sureties when they are bound to pay equally, and then when they are bound to pay different sums. Different rules we have in both the cases. So you will have to write, proper answer in this question. Next is discharge of surety. Explain the circumstances in which surety is discharged from his liability. Broadly speaking, friends, there are 3 ways in which surety is discharged from his liability. First one is by revocation. The term revocation means to take back, to revoke, to withdraw his guarantee. So, which you all know, friends, you know how the guarantee is revoked. But death of the surety by notice, okay. So the surety can revoke his guarantee by serving the notice also. So when the notice is served, then all the transactions which take place after the notice, surety will not be liable. And then by novation also, when new contract is substituted in place of old one, then also the surety is discharged from his liability. The second main category is by act or conduct of the creditor. Number of points are there, friends. Variation in the terms of the contract. Okay, compromises made. Then also, compromise may be made by the creditor with the debtor. Then also surety is discharged. Compounding with the debtor. Then, any act which impairs surety's liability. Loss of security as per section 141. So 5 points are there under this heading, act or conduct of the creditor. Then last is by invalidation of the contract of guarantee. The contract of guarantee becomes invalid. So when the contract of guarantee becomes invalid, then also surety is discharged from his liability. For example, when there is no consideration or other co-surety fails to join, or guarantee is obtained by fraud, or it is obtained by misrepresentation. So these are the circumstances when surety is discharged from his liability. Second special contract is, friends, contract of bailment and pledge. Question has been asked in DU and other examinations from this chapter, and all headings are there on the slide. The very first heading is definition of bailment and its essentials. Friends, bailment has been defined under section 148. Bailment is the delivery of goods by one person to another, where the goods are delivered for some purpose. When the purpose is over, the same goods are to be returned to the person who delivered them, or they are to be returned as per the directions of the person delivering them. So there are a number of features or essentials of contract of bailment. There are two parties involved. One is a bailer who delivers the goods, and the bailee is a person to whom the goods are delivered. There is a delivery of possession only. There is no delivery of ownership. There is no transfer of ownership. It is only the possession which is given by one person to another. This contract of bailment may be express or implied. And being students of business law, you all understand these two concepts, express and implied. Contract of bailment is always of movable goods. Because when we talk about delivery of goods, it is a movable goods only which can be delivered by one person to another. The same specific goods are to be returned when the purpose is over by the bailee to the bailer. So bailment contract has got multiple purposes. Goods may be bailed by one to another for helping him. Goods may be bailed by one to another which will benefit the bailer first. Say for example, bailer has no parking space and he has to organize trip. Then he tells his friend who has got enough parking space in his society, and he says, "You please keep this car for me for a period of 15 days as I have to organize a trip. When I'll come back from the trip, I will collect my car from you." Here the contract of bailment is for the benefit of the bailer. But when we take the example of contract of sale, or where the goods are taken on hire basis. Okay, so then in that case the hire charges are paid. Okay, so book has been taken on hire charge basis just to appear in the exam. Here this is also the contract of bailment, where both the parties will get the benefit. But if the book is borrowed from the friend, it means in that case it is the bailee's purpose which will be served. So friends, definition of contract of bailment as per section 148, and 7 points you have to write regarding this features of bailment. Next question is duties and rights of bailer and bailee. One of these two can be asked. Explain the different duties and rights of bailer, or explain the different duties and rights of bailee. So duties of bailer are the rights of bailee, and rights of the bailer are the duties of bailee. For example, bailer, when he bails the goods, he delivers the goods to the bailee, he must disclose all the defects in the goods bailed. If he is aware of the defects and he does not disclose, due to which loss is suffered by the bailee, then it becomes the duty of the bailer. He must disclose the faults in the goods bailed, which is the right of the bailee. If bailer has not disclosed the faults to the goods bailed, which he is aware of, and bailee suffers any amount of loss, bailee has a right to recover this loss from the bailer. So friends, when you write duties and rights, do write the sections also, because this is OBE examination where you are going to write from the book or from the notes, whatever. Next is distinction between general and particular lien. General lien is general. It is always exercised for the general balance of account. It can be exercised against any property. Different parties are entitled to this general lien. Particular lien is for particular purpose only. It can be exercised, against those goods only where some labor has been expended. Labor or skill has been expended. Particular lien can be exercised against particular property only. Till those charges are paid, the person has a right to retain the goods. Say a customer has given his clothes for dry cleaning purposes to the dry cleaner, and dry cleaning charges are to be paid. Till charges are paid, dry cleaner has the right to retain those clothes. But once the charges are paid, then dry cleaner has to return the clothes to the customer. So 3 to 4 points of distinction are there between general and particular lien, which you should write in the tabular form. Distinction between bailment and pledge. 3 to 4 points of distinction. Bailment, defined under section 148. You know the definition. Pledge has been defined under section 172. Pledge is a part of bailment. When goods are delivered as a security for the debt, it is known as the contract of pledge. The two parties involved, one is a pledger, other is the pledgee. So pledge is a part of bailment. Bailment has got multiple purposes, but pledge has got single purpose only. So bailment is a broader term, but pledge is a part of bailment, but bailment is not a part of pledge. So friends, bailment has got number of purposes, multiple purposes. Pledge has got single purpose only. In case of bailment, the person has the right to use. The person may have the right to use the goods. Bailee may have, but in case of pledge, pledgee has a right to sell the goods if the pledger commits default regarding payment of loan amount. And the last heading is pledge by non-owners. Very important question. Non-owners cannot make a valid pledge. Explain this rule and state the exceptions to this rule. So friends, it is very right that non-owners are not allowed to make a valid pledge. A person who is not the owner, how can he pledge the goods? But there are 6 exceptional cases where non-owners can also make a valid pledge. Say for example, pledge by mercantile agent, pledge by co-owner, pledge by person who is in possession of goods under wardable contract. Okay, or pledge by seller in possession of goods, after sale. Pledge by buyer in possession of goods after an agreement to sell but before sale. So these are the cases, friends, where non-owners can also make a valid pledge. Moving ahead, the last contract is contract of agency. Agency by ratification and its essentials. There are 4 ways in which agency may be created. First one is agency by express contract, agency by implied contract, agency by ratification, and the last is agency by operation of law. Contract of agency has been defined under section 185. So question is asked, friends, explain the various essentials of ratification. Or ratification tantamounts to prior authority comment. What is ratification, friends? Ratification is the adoption or acceptance of the act which was done by the agent without the authority of his principal. Agent has bought computers for which he was not given the authority, but he has bought computers. But principal, when he comes to know about this task, then he accepts this unauthorized act of the agent, expressly or impliedly. Impliedly means he makes a payment. So friends, this is known as ratification. There are 2 cases where one case is where the act is done with the prior authority of the principal. Second is where the act is done without the authority of the principal, but it is ratified subsequently. In both the cases, the liability of the principal will be the same. That is why we say ratification tantamounts to prior authority. It is equivalent to the prior authority. No doubt it is equivalent to the prior authority provided ratification is valid. And now the question arises, what are the requisites of valid ratification? What are the essentials of valid ratification? So friends, there are 12 points which have been provided under sections 196 to 200 of the ICA 1872. You will have to write these points and explain with the help of examples or case laws. 10 to 12 points. Okay, so the points may be ratification can only be of valid contracts. It cannot be of illegal contracts. At the time of ratification, the principle must have been in existence. The parties must be competent to contract. The whole act must be ratified. Like this, friends, there are 10 to 12 points which you have to write in your answer. Next question is delegatus non potest delegia. A delegate cannot further delegate. This has been laid down under section 190 of the ICA 1872. A delegate cannot further delegate. See, authority has been assigned by the principal to the agent. Now, agent cannot transfer this authority to somebody else. There's a general rule of law which has been provided under section 190. But there are certain exceptional cases which have been provided under section 190 of the ICA 1872 when a delegate can further delegate. That is, agent can delegate his authority. And the person who is so appointed will be known as sub-agent. Sub-agent has been defined under section 191. Substituted agent has been defined under section 194. So let me conclude the answer for the second question. Start from this law term, laws sentence, delegatus non potest delegia. Write the meaning of this and then give one example. Write those exceptional cases where 6 cases are there where a delegate can further delegate. There may be custom of trade or there may be express authority which will be given by the principal to the agent. If emergency arises or need arises, you can delegate your authority. Then coming to the third question under other chapter, contact of agency, distinction between sub-agent and substituted agent. I hope you must have understood the term sub-agent, which has been defined under section 191. For sub-agent, principal is the agent, and for agent, principal is the principal. The substituted agent has been defined under section 194. When principal gives the express or implied authority to the agent to give the name of somebody else who will be acting as the agent of the principal, and the principal does the same, then such person is known as co-agent or substituted agent and not sub-agent. So friends, for substituted agent, principal is the principal. And for sub-agent, agent is the principal. There are 5 to 6 points of distinction between sub-agent and substituted agent. So again, friends, I have told you number of times, distinctions must be written in the tabular form or T form. 4 columns. One is the serial number, second is basis, third is the third term, that is the first term, sub-agent, and the last will be substituted agent. Who is the principal for whom? Who is liable for whom? Okay, who is appointed by whom? Okay, and when each person's liability comes to an end. Who is answerable to whom? Okay, so all these points of distinction, and who works under the direction and control of which person. Second last question, which has been asked in the previous years in Delhi as well as in DU as well as other examinations, that is personal liability of agent. As per section 230, we always say, friends, all the acts of the agent are the acts of the principal, provided agent has acted within the authority. But if agent tries to cross the limits, he acts beyond the authority given to him by his principal, then in those cases, agent will be held liable on personal basis. So discuss the circumstances in which agent is held liable on personal basis. There are 12 points here. When principal is non-existent, when principal cannot be sued, when principal is undisclosed or concealed principal, as the name implies, principal remains undisclosed, unconcealed. Then also, agent is head liable on personal basis. Agency is coupled with interest is also one of the points. Principal is a foreign principal. Principal agent has done something which is beyond the authority and it has not been ratified by the principal. So there are 12 points which you have to write along with content as well as examples or case laws. Then duties and rights of principal and agent. Duties of the principal are the rights of agent and rights of the principal are the duties of agent. Agent should always follow the directions of his principal. An agent works within the authority of the principal, so agent is entitled to remuneration for all expenses which he may have incurred. So rights of the principal are the duties of agent and duties of the principal are the rights of agent. One of these two has been asked in the previous examinations. Duties and rights of principal or duties and rights of agent. So friends, in my today's video class, I have covered all the frequently asked questions in Delhi University examinations and other examinations. I hope you must have understood now. You will understand how to write the answer for these questions. So friends, I hope you will like these videos and do press on the bell icon so that you can get notifications of my subsequent videos. Stay blessed always. We'll meet again very soon. Okay friends, goodbye.